For what purpose does Mr. Roy seek recognition?
Speak on the Biggs Amendment.
With that, the gentleman is recognized.
Thank the chairman. I would note on the underlying measure, which I'll talk about more in a minute, the actual total number of deported veterans is unknown, but advocacy groups estimate the number to be around 300, to the best of my knowledge. And it's important to note that prior to removal, alien veterans are afforded due process through immigration removal proceedings and issued a final order of removal by an immigration judge. Now, I don't think any of us are not at least sympathetic to the question about service of a veteran and how that might affect their status in this country. But I'll have more to say about that in a minute with respect to the rules that apply to veterans, that should apply to everybody. But all the gentleman from Arizona is doing, I mean, if I understand correctly, is simply saying that the literal text of the bill is that an exercise of discretion under paragraph 1A may only apply if the victim of the crime, so there was a crime and there was a victim, agrees that the individual should receive the exercise of discretion and the individual has satisfied all obligations of restitution, fines, fees, and any other obligations associated with the conviction. So all this amendment is saying, for the world to understand, is for this subset of individuals, estimated to be around 300, maybe it's a little more, maybe it's a little less, even if we assume and accept the premise of the policy, which I think deserves a whole range of discussion and debate, that all that Mr. Biggs is saying is, okay, if the individual committed a crime, and our members of the military are not immune from the criminal proclivities of humankind, there are crimes committed, right? And then there's criminal justice for those crimes that are committed. So you commit a crime. And we're saying, well, don't victims have rights? And shouldn't that also be a part of the discussion about whether that individual gets permanent status in the United States, gets to stay in the United States? With the how many million people that are currently in line? How many people that are, known gotaways, 850,000 known gotaways over here in the last year and a half. We've got a completely broken border. We've got millions of people waiting to get here. Now you have an individual who served, and that's to their credit, but committed a crime. And all the gentleman from Arizona, I believe, is doing is saying, should we not account for the fact that the crime was committed, that the victim have a right to be able to be heard, a right to be able to present that, hey, this individual did this thing to me?
Would the gentleman yield?
I'll yield to the gentlelady.
I think the gentleman, and I would like to share with you the data that we received from the department in terms of...
if the gentlelady can make it reasonably...
I'll be very quick.
Expeditious.
Not all of the individuals who've been removed were convicted of anything, number one. And number two, some of the, who's the victim in a drug possession case or a nonviolent case, but additionally, it's not just consultation. This gives a veto to whoever the victim is. And
so the gentlelady, reclaiming my time,
and I thank the gentleman for you.
Don't run out of time. No, of course, I'm happy. I enjoy colloquies, and I think they're important. I think, number one, so not all are, committed crimes, but there are criminals. The amendment speaks to the extent to which there was a crime and there was a victim. And to the extent there was a victim, that the victim should have a say in the status of that individual in the United States. And I think that is fundamental to it. And the idea of the sort of victimless crime, right, of drug possession. The amendment speaks to that, right? I mean, I think what the gentleman from Arizona is rightly identifying is when an individual actually commits a crime, there is a victim, that the victim ought to be able to say, wait a second, why is that guy or gal getting to stay in the United States, getting green card, getting status, getting a path to citizenship, whatever it might be, if, hey, I was the victim, right? And I thank the gentleman from Arizona. I support his amendment. I'll yield the 28 seconds to him if he wants to add anything.
I thank the gentleman. I'll just go quickly. When I hear the arguments against this, it seems consistent with the entire leftist Democrat mantra of favoring victims over criminal defendants. This goes right to, if it's a victimless crime, if it's a DUI, let's say it's a DUI, you don't have a victim.
Gentleman yield.
This would not apply.
Gentleman yield.
It's my time and it's out. I yield back.
Gentleman's time has expired. Who seeks recognition? What purpose does the gentleman from Rhode Island seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman, and thank you for bringing this important bill to markup. I rise in opposition to the amendment and in support of the underlying bill. With respect to the amendment, I would just say briefly, we don't have a private system of justice in this country. We have judges who make determinations and judgments all the time, but we don't allow individuals to determine the outcome of particular matters, and I think that's a very dangerous precedent, and that's why I think the amendment is not a wise one. But I want to thank you, Mr. Chairman, for bringing this really important bill to markup. Immigrants have always played an important role in our military, and their sacrifices to our country must be honored. 45,000 immigrants currently serve in our armed forces, and 2.4 million veterans, representing 13% of all veterans, are immigrants or the children of immigrants. The prior administration dismantled our immigration system, including for our immigrant veteran population, even wrongfully deporting veterans in violation of ICE policy. This legislation makes our immigration system more accessible to and fair for the brave immigrants who have fought for our country. Service members who make such incredible sacrifices for this country deserve a fair chance to make a home in the United States, regardless of their immigration status. I can think of few things that are more deserving of American citizenship than laying your life on the line for this country, our people, and our democratic values. I think the title of this bill, the Veteran Service Recognition Act, says it all. These veterans and service members must have their service recognized without burdensome hurdles. This is a matter of fairness, and we have a duty to honor our commitment to those who serve our country. I want to thank Mr. Takano for his leadership on this bill, and I urge passage of this legislation. And I'm happy to yield to the gentlelady from California.
I thank the gentleman for yielding. I just, listening to our colleague from Texas estimate that the number of people we're talking about is 300. I'm hoping that we don't spend 300 hours talking about that small group of people. There are in this measure provisions to protect public safety and the like. But I would note that from the information we've gotten from the MVETs that was revealed at our hearing, of the people who've applied for the administrative program, most of them are over 40. Most of the convictions are over 10 years old. Actually, the vast majority are 10 or 20 years old. It's important to note that the individuals who've been removed, they were legal permanent residents of the United States in almost every case. That's how they were able to be in the U.S. military. They could have naturalized if they had understood the process. Part of this bill is to ask our Defense Department to do a better job of having veterans, having our military personnel understand and access the naturalization opportunities. But I'll say this, all of us here, most of us here, had the good fortune, I'll just speak about myself, I feel lucky, so fortunate that I was born in the United States of America, that I'm an American citizen. I'm proud of that, and I'm grateful, and I'm happy. But I'll say this, if someone wants to sign up and risk their life in the United States military to defend our country, they're doing more to become an American than I did. I just had the good luck to be born here. And I think to strip them of their legal permanent residence, if they make a mistake after their service, is not the right thing to do. The Department of Defense estimates that up to 30% of the people who serve in our military suffer from post-traumatic stress disorder, and that is a major cause of problematic behavior, untreated PTSD. And so you have, if you take a look, and we're trying to get copies for all the members on the Republican side of the aisle, you have most of the these convictions are related to, or could very well be related to the service that the individuals had. And remember, this is not an automatic right. This gives discretion to the Department of Homeland Security Secretary to take a look at a case-by-case basis to see whether there should be a return for these 300 people that Mr. Roy has talked about. And I yield back, Mr. Cicilline, with appreciation.
And I yield back, Mr. Chairman.
For what purpose does the gentleman from North Carolina seek recognition?
To speak on the amendment.
The gentleman is recognized.
I thank the chairman. And I came in late, so I was a little bit disadvantaged as I was reading the amendment and then hearing sort of the vociferous objections to it, and I didn't even understand it. I think it worth hearing, though, that what the, so Mr. Roy commented on or mentioned the relatively small number of veterans who were susceptible to deportation who were known, 300-something. Ms. Lofgren just spoke to that, and there was a little bit of information about them furnished to me that I thought worth making the committee aware of. That GAO report in 2019 said 68 veterans, 78% of them, were ordered removed because of at least one aggravated felony conviction, while the remaining 19, 22%, were ordered removed for non-aggravated felony convictions. Of the convictions I cited on the 87 veterans NTAs, 32 veterans had drug-related convictions, 20 had convictions related to sexual abuse, of which 18 involved minors. 21 had convictions related to homicide, assault, or attempted homicides or assaults. 16 had theft-related convictions, and 9 had convictions related to firearms, explosives, or explosive materials. I don't really understand, as sort of to the underlying bill, why this notion that that the criminal conduct of admittedly veterans, but their criminal conduct in this particular instance should be sort of wiped clean.
Would the gentleman yield?
No, I've got one more point to
Okay.
finish, and then I'll do that, Ms. Lofgren. Why that would be wiped clean, and then I see, you know, you could arguably say the bill doesn't do that because it imports a discretion, and I'm a little uncomfortable. We'll say I'm very uncomfortable given the administration, the Biden administration's track record on immigration. I'm reticent to furnish yet additional discretion to the Homeland Security, or the Secretary of Homeland Security, because of the way it's been abused. But Mr. Biggs's amendment is so modest. It simply says, so you go back to that category of the 20 who had convictions related to sexual abuse, of which 18 involved minors. And this gives deference to the victims who suffered those crimes. And then that's characterized by the gentleman from Rhode Island as being private justice. I got to tell him, get up to speed, because there's been a revolution of victims' rights recognition in the country that's been going on for 20 or 30 years now. That is not private justice. This is a very modest amendment, and it's outright rejection, and even this kind of glowing, deference to service in the military, even to the disregard of grotesque criminal conduct, I don't get. I don't think it's very balanced, and I agree, I don't think we ought to have to debate over 300 so people for extended time, but the presentation of the bill, particularly if it's not going to be able to be modified at all in reasonable ways, unfortunately invites the situation. And yes, I do yield to the gentlelady from California.
I appreciate that. I would like to note that on page 14 and 15, there are provisions that disqualify an applicant if there are grounds to believe the applicant is a risk to national security, if the applicant has committed or conspired to commit significant human trafficking offenses, if the applicant has been convicted of any of the following aggravated felonies: murder, rape, sexual abuse of a minor, crimes related to the operation of a prostitution ring and related human trafficking, or crimes related to the production, sale, possession of child pornography. Those cannot be waived. I would note,
Let me at that point reclaim my time. I'll give you more if I get done, but just to make the point that this 19-person advisory council is not restricted by those limitations at all. It can allow these folks in despite
That's
all
not
those
correct.
grotesque
That's incorrect.
convictions. Let me yield to Mr. Tiffany.
I'll just put a finer point on this. You expect us to have full confidence in the current Secretary of Homeland Security, where the Border Patrol has said that he has lied about our border being secure, that he's done everything possible to funnel people into our country illegally, and you want us to give greater authority to him? That's reckless, and it's just wrong to do it. I yield back to the gentleman.
let's vote. Yep.
I ask who seeks recognition, and I seek recognition, and I would yield my time to the gentlelady, Ms. Lofgren.
Yes, just a couple of clarifications here. The advisory committee that's been referenced has no authority to grant anything. They can give their advice to the secretary, but the secretary is limited by the elements of the bill itself. An applicant who has committed any of the offenses or poses any of the risks that I just read is ineligible for relief. On the issue of whether discretion can properly be exercised, as we know from our hearing, the Immigrant, Military, Members, and Veterans Initiative that the Department of Homeland Security is currently operating has received about 60 requests for relief and return to the United States from veterans and their families. Of these requests, 16 were granted and 8 were denied. So it's not as if, willy-nilly everything is going to be approved. And as for, I was a member of this committee in 1996 when we changed the definition of aggravated felony to something that is not commonly thought of as aggravated felony. The vast majority of the convictions mentioned in the GAO report are drug offenses. Now, I'm not for drug offenses. I think it's a serious problem. I know that people across, especially people who have suffered from PTSD, oftentimes turn to drugs to try and deal with the trauma that they're experiencing. That is a terrible thing. But I don't think the fact that someone has turned to drugs to solve a PTSD problem should disqualify someone from at least the potential of receiving relief. If they were a legal permanent resident of the United States, they had their status stripped after they were convicted and paid their penalty, whether it was jail or a fine, and now have been ousted from the United States and the country that they served in the military. That is not, I think, in keeping with the kind of country we want to be here, to honor those who served our country in the United States military. I would note that once again, that the advisory committee has no authority whatsoever, and the secretary is constrained, cannot consider applicants who've been convicted of any of the following aggravated felonies: murder, rape, sexual abuse of a minor, crimes relating to operation of a prostitution ring related to human trafficking, crimes related to the production, sale, or possession of child pornography, anyone who's committed or conspired to commit significant human trafficking exceptions, or anyone, if there's a reasonable ground to believe that the applicant is a risk to national security. So I would hope that we could put our veterans ahead of our politics in this markup, and that we could come together and enact this measure that will honor our veterans. As I mentioned in my prior remarks, you know, discretion, the parole in place discretion for veterans and their families has been used many, many times. And actually, during the Trump administration, was used about 20,000 times. So this doesn't have, we don't have to get diverted into a partisan fight on this bill. We can come together, we can honor our veterans, and we can approve the bill and make it law, and I hope that we will. And with that, Madam Chairwoman, I yield back.
And I'll reclaim